on behalf of all, I congratulate him. And to the topic, this topic even is a very important topic in today's scenario. That too in the current scenario. The topic even is today's remedy available with the state government when the governor's inaction on the advice of Council of Ministers. That is when the Council of Ministers are advising the governor. Suppose if the governor is not at all giving it, what is the remedy available to the state government? So this our Saravaja sir will explain. The main point to be emphasized in this speech is whether in a democratic country like India, when the people have elected 234 MLAs in the state government, whether the people's mandate is final or government who was appointed by the government is final. This is the final point to be decided in a democratic country. That has to be decided today. Thank you. Over to Mr. Saravaja.
And I strongly believe that when we go to Haridwar or Rishikesh and to have a holy dip in holy Ganga, it is believed that it removes the sins committed by the people and it gives a new life. In the same manner, I consider our holy Thingal vithaigal, which will remove our sins of ignorance and bless us with knowledge of new life. With this good thought, let me start with this topic for today. So today, the entire discussion would be on Perarivalan's case. Before going into the substantial question of law, let us deal with the facts of the case in brief. Therefore, when we take care of the facts of the case, automatically the law will take care of the facts. So let me start from the date of 21st May 1991. This was the day where the former Prime Minister of India, late Rajiv Gandhi, was assassinated in a terror attack at Sriperumbudur in Tamil Nadu. A case was registered and investigation carried out by Central Bureau of Investigation. The Perarivalan, along with other accomplices, was apprehended and tried for various offences. The accused persons were convicted and sentenced to death by the trial court. Thereafter, the matter reached before the Honorable Supreme Court. Honorable Supreme Court also, by judgment dated 11th of May 1999, they have confirmed the death sentence of Perarivalan and others. After the confirmation of the death sentence by the Honorable Supreme Court, a mercy petition was filed by Perarivalan before the President of India. This was filed on 26th April 2000, but the President could not decide the mercy petition within a short period of time. He has taken almost 11 years and finally the mercy petition was rejected after 11 years. Thereafter, after rejection of the mercy petition, Perarivalan filed a case before the Honorable Supreme Court saying that the delay in disposal of the mercy petition is itself a violative of the fundamental right. Therefore, in light of the judgment held in Shatrughan Chauhan and others, wherein the Honorable Supreme Court held that undue and unexplained delay in deciding mercy petitions was a legitimate ground for the death convicts to approach the apex court seeking commutation of death penalty to life imprisonment. In light of this decision, a ground was taken by Perarivalan and other accused that his mercy petition was rejected after 11 years. Therefore, inordinate delay is itself a violation of his fundamental right under 21. Therefore, he sought commutation of death sentence to life. So, Honorable Supreme Court, while considering his petition in light of the judgment of Shatrughan Chauhan, the Honorable Supreme Court commuted from death sentence to life imprisonment. And in that case, they have held also life imprisonment means it's end of one's life. Subject to any remission granted by the appropriate government under section 432 of the Code of Criminal Procedure 1973, which in turn is subject to the procedural checks mentioned in the said provision and further substantive check in section 433A of the Code. So after the judgment where the Honorable Supreme Court commuted from death sentence to life imprisonment, immediately on the very next day of the aforesaid pronouncement, whereby death sentence of convicts was altered to life imprisonment, the government of Tamil Nadu, by letter dated 19 February 2014, proposed to remit the sentence of life imprisonment of all 7 life convicts in the late Rajiv Gandhi assassination case. The said decision of the government of Tamil Nadu was challenged before the Supreme Court of India by the central government. And the matter came up before a 5 judges bench because the constitutional issues are involved. So it was decided by the 5 judges bench, and holding that the Honorable Apex Court ruled that in facts of the present case, the decision of government of Tamil Nadu was without the consultation or the concurrence of the union government, and therefore they cannot release these prisoners without the concurrence of union government. Therefore, the decision taken by the Tamil Nadu government was bad in law. So this is what the Honorable Supreme Court held in Union of India versus Sriharan and others. So after the 5 judges bench, there was a fresh proposal by the Tamil Nadu government. Thereafter, the government of Tamil Nadu made a fresh proposal dated 2016 to the central government, proposing remission of life convicts under scheme of 435 of CRPC. The communication remained under consideration. 3-judge bench of the Honorable Supreme Court, with order dated so and so, they passed an order by giving a direction to the Union of India to decide the fresh proposal by the Tamil Nadu government within a period of 3 months with effect from today, that is 23/1/2018. In pursuance to the order passed by the Honorable Supreme Court, it was considered by the central government, and central government, this is what they have done. The central government, in pursuance of section 435 of the Code of Criminal Procedure 1973, they did not concur to the proposal of the government of Tamil Nadu contained in their communication letter dated so and so for grant of further remission of sentence to these 7 convicts. Thus, the central government is opposed to the release of the life convicts in the matter. So based on the decision taken by the Union of India, it was reported to the Honorable Supreme Court, where the writ petition was pending. So in view of the order dated 18/4/2018 passed by the Joint Secretary, Government of Tamil Nadu, Bharat Sarkar so and so, nothing would survive for consideration in this writ petition. It is accordingly closed. From the documents filed on 1st September 2018 by the Learned Counsel, it appears that an application under Article 161 of the Constitution has been filed before the Governor of Tamil Nadu by the respondent. The Governor will be at liberty to decide the said application as deemed fit. So this was the order passed by the Honorable Supreme Court on 6th of September 2018. After this, meanwhile, Perarivalan had applied to the Governor for pardon on December 30, 2015, and almost 3 years later, on 6th September 2018, the Supreme Court asked the Governor to decide the pardon plea as he deemed fit, and 3 days after the Honorable Supreme Court's order, on 9th September 2018, the Tamil Nadu Cabinet recommended to the Governor to remit Mr. Perarivalan's sentence and release him forthwith. So this decision was made by the cabinet on September 9th, 2018. After receipt of this recommendation, what did Governor did? The Governor of Tamil Nadu has continued to withhold his decision on an application seeking pardon filed by AG Perarivalan despite the advice of the Council of Ministers for releasing Perarivalan. However, the Governor has not yet acted on it for over 2 years from the date of Cabinet's decision, that is 9th of September 2018, and 5 years from the date of application filed by Perarivalan, which was the date was 30th December 2015. So this inordinate delay raises the following substantial questions of law involving constitutional importance. So this is a short as well as a short brief facts of the case. Now let us move on to the questions of constitutional importance. So I wanted to place 4 issues before your kind consideration. There are 4 issues I have framed. First issue is whether the Governor, while exercising his power under Article 161 of the Constitution of India, is required to take advice of the Council of Ministers or not. Second question is, what is the constitutional duty vested upon the Governor after receipt of Cabinet decision? And third issue would be, what is the remedy available with the state government when Governor's inaction on advice of the Council of Ministers? And lastly, can Honorable Supreme Court direct the constitutional authority like Governor to exercise his power under Article 161 of the Constitution of India within time-bound manner or any other directions as it deems fit? So these are the 4 issues involving constitutional importance I have framed, and let me try to answer those issues with substantial provisions of law as well as the decisions rendered by the Honorable Supreme Court. Now let me move on to the first issue of constitutional importance. So the first issue is whether the Governor, while exercising his power under Article 161 of the Constitution of India, is required to take advice of the Council of Ministers or not. So to understand this issue, we must study Article 161 first, because Article 161 is a constitutional provision which deals with power of Governor to grant pardons, etc., and to suspend, remit or commute sentences in certain cases. The Governor of a state shall have the power to grant pardons, reprieves, respites or remissions of punishment, or to suspend, remit or commute the sentence of any person convicted of any offence against any law relating to a matter to which the executive power of the state extends. The point to be noted here is, there is no express mention in this article to say that the Governor must act with the aid and advice of the Council of Ministers. From the simple reading or from the plain reading of Article 161, it shows that the power of Governor, he has got the enough power, immense power to grant pardons, to remit or commute the sentence. But let us see, before dealing with this, let us understand what is pardon means, what is suspension means, what is remission, everything that we will see the definitions. And let me take you now to chapter 32 of CRPC, which deals with from section 413 to 435, which deals with, it is a exclusive, this chapter has devoted on the subject of execution, suspension, remission and commutation of sentences. And Indian legal mechanism provides pardoning power sourcing from both statutory and constitutional authorities. By virtue of Article 72 and 161 of the Constitution of India, the President and the Governor can grant pardon to suspend, remit or commute a sentence passed by the court. In addition to the above constitutional provisions, the Criminal Procedure Code 1973 provides for suspension, remission and commutation of sentences. And section 432, it is a power to suspend or remit sentences. 433, power to commute sentences. And 433A of CRPC, which deals with restriction on power of remission or commutation in certain cases. 434, concurrent power of the central government in case of death sentence. And 435, state government to act after consultation with central government in certain cases, empower the government to suspend or remit or commute sentences. So now the point is to be noted here is, why should we have the power under CRPC also and as well as under the constitutional provisions? As far as my understanding, this constitutional provision is vested with the President and the Governor of a state, and this CRPC, these provisions which empower the state government to remit or commute the sentences, provided they seek the consent from the Government of India, Union of India. For the reason, this case, the entire case was investigated by the CBI, Central Bureau of Investigation, which comes under the central government. Therefore, the central government concurrence is required as per section 435. So let us understand what is the meaning of pardon. Meaning of pardon in simple terms, forgiving a person. In this case, Perarivalan is a life prisoner and he is in jail. If pardon is allowed by the governor, he will be forgiven and he will be released from the jail. What is reprieve? Reprieve means it's something, a temporary delay in imposition of the death penalty by the executive order of the governor of the state, and it is not a reduction of sentence or commutation of sentence or pardon. It is merely a temporary delay. And let us understand what is respite. It denotes awarding a lesser sentence in place of one originally awarded due to some special fact such as the physical disability of a convict or the pregnancy of a woman offender. And what is remission? Remission means it is shortening the period without changing its nature. For example, reducing 20-year rigorous imprisonment to 10 years. And what is commutation? The definition of commutation is the act of substitution, changing the nature of punishment like from death sentence to life imprisonment. So while we should understand all these terms, because these are the terms used under Article 161, and 161 gives power to the governor to exercise, to remit or to respite or to commit the sentences. Now let us move on to another important article, which is Article 163 of the Constitution of India. Article 163 of Constitution, which deals with Council of Ministers to aid and advise governor. And there shall be a Council of Ministers with the Chief Minister at the head to aid and advise the governor in the exercise of his functions. Except, so the first the half portion of Article 163 Clause 1 says the governor should act in exercise, the governor should exercise his power with the help and the advice of the cabinet ministers, where chief minister is the head. But there is a small exception clause is also provided in the same clause. Except in so far as he is by or under this constitution required to exercise his functions or any of them in his discretion. So when the governor exercises his discretion, he need not seek the advice of the cabinet ministers or from the state. That is what clause 1 says. And clause 2, if any question arises whether any matter is or is not a matter as respects which the governor is by or under this constitution required to act in his discretion, the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion. So when the governor exercises his discretionary power, that becomes final and that cannot be questioned by any court. That is what clause 2 says. And clause 3 of Article 163, the question whether any and if so what advice was tendered by ministers to the governor shall not be inquired into in any court. So this is what the plain reading of 163 is. Now the question before us is whether exercise of power under Article 161 is a discretionary power of governor and whether he can take his independent decision or he must act with the advice of Council of Ministers. So that is a question staring at us. But through a plain reading of Article 161, there is no mentioning that governor should act with the advice of the Council of Ministers coupled with discretionary power provided under Article 163 Clause 1. But we all know that the final interpreter of the Constitution is the Honorable Supreme Court. So what did Honorable Supreme Court say about the exercise of power under Article 161? So let us move on to the case laws wherein the Honorable Supreme Court had an occasion to decide the powers and functions exercised by the Honorable President of India under Article 72 as well as the powers exercised by the Governor under Article 161 of the Constitution of India. So this is in Maru Ram versus Union of India, 1980 cases, 1981 SCR Volume 1, 1196. This was a 5 judges bench, a constitution bench. In this case, the issue before the Honorable Supreme Court was the constitutional validity of Section 433A of the Criminal Procedure Code 1973 was questioned, mainly on the ground that it indirectly violates Article 72 and 161 of the Constitution of India. So this was the issue. When the pardoning power given to the President under 72 as well as to the Governor under 161, what is the need for Section 433A, which deals with restrictions on powers of remission or commutation in certain cases? So according to the petitioners, they argued before the Honorable Supreme Court, it is indirectly violating Article 72 and 161. But the Honorable Supreme Court, in its wisdom, they have upheld the validity of Section 433A, and the Honorable Supreme Court held that it is not violative of Article 72 as well as not a violation of Article 161. So while upholding the validity of section 433A, they dealt with, the Honorable Supreme Court dealt with the powers exercised under 161 as well as the power exercised by President under 72. So what did Honorable Supreme Court said in this judgment? Let us see. The power, this is what the Honorable Supreme Court held. The power under Article 72 and 161 of the Constitution can be exercised by the central and state governments, not by the President or Governor on their own. See, by plain reading of 161, we just now said or discussed or we inferred that there is no express mentioning of the Governor seeking advice from the Council of Ministers. But through the interpretation of the constitutional provisions by the Honorable Supreme Court, the Honorable Supreme Court said that the power under 72 and 161 of the Constitution can be exercised by the central and state government. They have not said it is exercised by the President or exercised by the Governor. They cautiously used the term it is exercised by the central and state governments and not by the President or Governor on their own. Further, the constitutional conclusion is that the Governor is but a shorthand expression for the state government. The Governor, though he can be considered as an executive head of a state, but still he is nothing but a shorthand expression for the state government, and the President is an abbreviation for the central government. Further, the Honorable Supreme Court held the advice of the appropriate government binds the head of the state. See, from this, what the Honorable Supreme Court has said, the decision given by the Cabinet or the recommendation made by the Cabinet will bind on the Governor. The advice of the appropriate government binds the head of the state, and no separate order for each individual case is necessary, but any general order made must be clear enough to identify the group of cases and indicate the application of mind to the whole group. And consideration for exercise of power under 72 under Article 161 may be myriad and their occasions protein and are left to the appropriate government. So the Honorable Supreme Court has said the President as well as the Governor or the mere executive of the state, it is a decision has to be taken substantially by the government and not by the President or by the Governor. Therefore, the decision taken by the Cabinet of Tamil Nadu government will bind on the Governor. This is what the Honorable Supreme Court said in this case. And whether, further they have said, whether the decision taken by the Governor, is it amenable to judicial review? The Honorable Supreme Court answers, but no consideration nor occasion can be wholly irrelevant, irrational, discriminatory or mala fide. Only in these rare cases the court will examine the exercise. So the point to be noted here is court has got a power to exercise its judicial review over the decision taken by the Governor or by the President under 72 or 161 of the Constitution of India, but the scope of judicial interference is very, very limited. Further, going further, Governor cannot act on their own. In further case, in yet another case, the Honorable Supreme Court decided in Nebom, Ribia and etc. versus Deputy Speaker. This is also a constitution bench. In this bench, the Honorable Supreme Court held that in discharge of executive functions, the governor of a state has the power to grant pardons, reprieves, respites or remissions of punishment, or to suspend, remit or commute sentences under 161. The governor's power under Article 161 is undisputedly exercised on the aid and advice of the Chief Minister and his Council of Ministers. I repeat once again, because this has a bearing on today's discussion. The governor's power under Article 161 is undisputedly exercised on the aid and advice of the Chief Minister and his Council of Ministers. So from the discussion that we have made in light of the constitutional provisions as well as the judgments rendered by the Honorable Supreme Court in these two constitutional bench judgments, let me try to answer the first issue. The first issue before us was whether the governor, while exercising his power under Article 161 of the Constitution of India, is required to take advice of the Council of Ministers or not. So the answer is, in my humble submission, it is my humble submission that in light of the decisions of the Honorable Supreme Court, it can be safely concluded that governor, while exercising his power under Article 161 of the Constitution of India, is bound to take advice of the Council of Ministers. So he cannot exercise his discretionary power. There is no discretionary power at all vested with the governor under Article 161. And taking it further, the recommendation made by the cabinet, it binds on the governor. He cannot take any other option, or he has no other option to exercise except to accept the recommendation of the cabinet. So with this, let me move on to the second issue before us. The second issue is, what is the constitutional duty vested upon the governor after receipt of cabinet decision? So in this case, in what we are discussing it today, in Perarivalan's case, cabinet decision was taken 2 years back in the year 2018 that they recommended for release of Perarivalan, and that recommendation was placed before the governor to take a decision. But His Excellency Governor is not acting upon the recommendation made by the cabinet decision. So what is the constitutional duty vested upon him? What is he supposed to do? The answer is, again, I will take the reference from the Constitution Bench judgment in Maruram versus Union of India. The Honorable Supreme Court have held that the advice of the appropriate government binds the head of the state, that is the governor of the state. Therefore, the governor has no other option except to accept the recommendation of the cabinet decision. And now he has to accept the recommendation of the cabinet, whatever the decision taken by them. Now he is not acting upon the recommendation. Now the question staring at us is whether the governor must act within a reasonable time. What is the time limit prescribed under the constitutional provisions? So the answer we can find out from referring to the yet another case decided by the Honorable Supreme Court in Shatrughan Chauhan and another versus Union of India and others. This was decided by 3 judges bench. The issue before this Honorable Court was, a writ petition was filed under Article 32 of the Constitution seeking relief against alleged infringement of certain fundamental rights on account of failure on the part of the executive to dispose of the mercy petitions filed under Article 72 and 161 of the Constitution within a reasonable time. And this was the issue before the Honorable Supreme Court, and the Honorable Supreme Court held that laid on a law. It is a well established that exercising of power under Article 72 as well as under Article 161 by the President or the Governor is a constitutional obligation or not a mere prerogative. Considering the high status of office, the constitutional framers did not stipulate any outer time limit for disposing the mercy petitions under the said articles, which means it should be decided within a reasonable time. So the constitution provision did not prescribe any time limit, but it is understood and it is expected from the head of the state to exercise his power within a reasonable time. And this is what the Honorable Supreme Court held in this judgment. However, when the delay caused in disposing the mercy petition is seen to be unreasonable and unexplained and exorbitant, it is the duty of this court, that is Honorable Supreme Court, to step in and consider this aspect. Right to seek for mercy under Article 72 as well as under Article 161 of the Constitution is a constitutional right. I repeat, it is a constitutional right and not at the discretion of whims of the executives. Every constitutional duty must be fulfilled with due care and diligence. Otherwise, judicial interference is the command of the Constitution for upholding its values. So this is what the Honorable Supreme Court held in this judgment. Further, the Honorable Supreme Court held that, remember, retribution has no constitutional value in our largest democratic country. In India, even an accused has a de facto, which means exists in reality even though not officially recognized by law, de facto complainant protection under the Constitution, and it is the court's duty to shield and protect the same. Therefore, we make it clear that when the judiciary interferes in such matters, it does not really interfere with the power exercised under Article 72 or 161, but only to uphold the de facto protection provided by the Constitution to every convict, including death convicts. So in light of this judgment rendered by the Honorable Supreme Court, let me try to answer to the second issue. The second issue before us is, what is the constitutional duty vested upon the governor after receipt of cabinet decision? As per Article 161 of the Constitution of India, and in light of the decision of the Honorable Supreme Court in the case Maruram and Shatrughan Chauhan's case, in Maruram case, the Honorable Supreme Court held that the decision or the recommendation made by the cabinet has a binding nature upon the governor. And Shatrughan Chauhan's case, the Honorable Supreme Court have held that there should not be any inordinate delay and there should be an immediate disposal of the mercy petitions within a reasonable time. So the constitutional duty vested upon the governor is to act upon the recommendation of the cabinet minister on order for release of Perarivalan. So this is my humble answer to the second issue in light of the judgments pronounced by the Honorable Supreme Court. Now let me move on to the third and fourth issue. I have clubbed together. The third and fourth issue before us is, what is the remedy available with the state government when governor's inaction on advice of the Council of Ministers? And the fourth issue is, can Honorable Supreme Court direct the constitutional authority like governor to exercise his power under Article 161 of the Constitution of India within time-bound manner or any other directions as it deems fit. So the answer lies in this judgment pronounced by the Honorable Supreme Court. This Supreme Court, the Honorable Supreme Court in Yapuru Sudhagar and another versus Government of AP. This was decided by the Honorable Supreme Court on 11th October 2006. In this case, the Honorable Supreme Court has held that the position therefore is undeniable that judicial review of the order of the President or the Governor under Article 72 or 161 as the case may be is available and their orders can be impugned on the following grounds. So on what grounds we challenge the report or the recommendation made by the President or by the Governor, the decision, how it can be challenged. Number one ground before the attack is that the order has been passed without application of mind, that the order is mala fide, that the order has been passed on extraneous or wholly irrelevant considerations, that relevant materials have been kept out of consideration, that the order suffers from arbitrariness. So if we read the grounds, it has always said the orders passed that can be attacked. But in the peculiar circumstances like what we are facing today, there is no order at all. How it can be challenged? My humble submission before your consideration is, when the order is passed either by the Governor or by the President, if that can be challenged through court of law under Article 32, even non-performing their constitutional duties will also entitle the Honorable Supreme Court to pass orders under Article 32. In light of the said decisions and Shatrughan Chauhan case, the remedy lied before the Honorable Supreme Court under Article 32. Because if there is an inordinate delay in considering the mercy petition, definitely it would amount to violation of Article 21. That is what the Honorable Supreme Court held in Shatrughan Chauhan's case. Therefore, the pendency or the inordinate delay before the Governor will amount to violation of Article 21 of Perarivalan fundamental right. Therefore, the remedy will lie before the Honorable Supreme Court under Article 32 on the ground of inordinate delay in disposal of his mercy petition. Now, what is the remedy or what is the power vested with the Honorable Supreme Court to pass orders? My humble submission is, whenever there is a right given to a citizen, he should not be remediless. And we know that the protector of the Constitution is the Honorable Supreme Court. And Article 32 is the heart and soul of the Indian Constitution. That is what B.R. Ambedkar said. Therefore, the Honorable Supreme Court, being the custodian of the Constitution, being the custodian of the fundamental right of each individuals of this country, the Honorable Supreme Court can pass orders under Article 32 itself, holding that the petition which is pending before the Governor can be decided immediately within a time-bound manner, or even they can release Mr. Perarivalan by invoking power under Article 142 to do complete justice. The Supreme Court becomes supreme by availability of Article 142. And if you ask me a question whether Article 142 in a similar situation whether the Honorable Supreme Court has exercised their power. Yes, the answer is yes. The case law in which the Honorable Supreme Court has released the prisoner by invoking Article 142. So the case law is, the name of the case is the Home Secretary Prison versus H. Nilofer Nisha. This was decided very recently on 23rd January 2020. The main issue before the Honorable Supreme Court was whether a writ of habeas corpus would lie for securing release of a person who is undergoing a sentence of imprisonment imposed by court of competent jurisdiction, praying that he be released in terms of some government orders, rules providing for premature release of prisoners. See, in this case, in Perarivalan's case also, there is a recommendation by the Cabinet Minister for release of Perarivalan. So let us see further what the Honorable Supreme Court said in this case. This young man, this is what the Honorable Supreme Court has discussed in this case. This young man who may have committed a heinous crime has obtained various degrees, including Masters in Computer Application, Masters of Business Administration, Master degree in Criminology and Criminal Justice Administration and MA in Journalism and Mass Communication, and various other vocational diplomas. The learning which he has obtained in jail must be put to use outside. Even in Perarivalan case also, he has also pursued degree while he was in jail and he has successfully completed. And the jail record shows that his behavior in jail has been satisfactory. The only ground against him is that he had murdered a person from another community, and therefore it is said that some religious enmity may still prevail. It has come on record that on various occasions he has gone back to his native place, though through police escort. We are clearly of the view that in these circumstances, this is a fit case where we should not send this respondent to another round of litigation. Therefore, in exercise of power under Article 142 of the Constitution, we direct the release of the respondent. So, answering the third and fourth issue, the third issue before us is what is the remedy available with the state government or with Perarivalan when governor's inaction on advice of the Council of Ministers. The remedy is Article 32 before the Honorable Supreme Court, and the Honorable Supreme Court can pass any orders as it deems fit, even under exercising its power under Article 32 itself, or otherwise it may invoke Article 142. This Perarivalan's case being a very peculiar case, even the Honorable Supreme Court can exercise its extraordinary power under Article 142 to do complete justice and release Perarivalan forthwith. So with this, I conclude by answering all these four issues, and this is my humble opinion, and I place it before you all for kind consideration. Thank you so much for patience hearing and giving me this platform to express my thought. Thank you so much. Greatly obliged.